The hearing will start now. This is originating litigation 322, summonses 448 and 475 of 2023.
All right, good morning, Ms. Sheila Ang, Mr. Benedict Tijapranoto, Ms. Naomi Lim, Mr. Craig Chua.
Yeah, perhaps just to, as a matter of housekeeping, Mr. Craig Chua is a practice trainee at the firm. If you are grateful, Your Honor.
Thank you. All right, and for the 5th to 9th non-parties representing various creditors, Mr. Chua Swee Tong and Mr. Russell Ng.
That's right, Your Honor. Good morning.
All right, good morning. Let me and Mr. Zoom allocation first. So parties are reminded there's to be no unauthorized photography or recording in any form and no dissemination of any photographs or recording of these proceedings, and only those counsel or persons notified to the court should be present at its location, and parties should treat these proceedings as they would a physical hearing. All right, before we begin, I believe there are a number of attendees are also in the viewing room. The proceedings this morning will be focused on the legal arguments for extension as well as the new non-parties application for permission to proceed with their winding up application. So because the arguments will be primarily legal, I will not be giving time this morning to comments or views or expressions of concern from the other attendees. The arguments will be legal. We received quite a number of emails in the meantime. So those will be addressed in the course of the proceedings, but unlike previous hearings, I will not be allowing other attendees to raise their hands and to speak this morning, since we will be focusing on the legal aspects. And similarly, the chat box is disabled this morning. All right, so we'll be proceeding on the basis that much of the morning will be given to the legal arguments. I'm not likely, I think, to be able to come to a decision this morning, and I'm likely to reserve judgment at least for a little while. All right, with that out of the way, turning to the lawyers present, Ms. Ng and Mr. Chua, I will take the extension and application to proceed together, and I will let both sides respond as needed. I think it will be best for me then to turn to Ms. Ng. Ms. Ng, I read through what I could this morning of your submissions. You can focus on the main points, and you can raise anything that you think would be pertinent in determining summons 475 as well. All right, please proceed.
Grateful, Your Honor. And what I propose to also do is that as I make my submissions, I will also address the concerns that have been raised by creditors in their emails to the court at the start, because they do twine in with my legal submissions as well.
All right.
Now, perhaps start for summons 448, it's the company's application for an extension of the moratorium to the 10th of April. And this is to do basically two things. One, to finalize the explanatory statement and the scheme of arrangement terms. And two, make an application to court for leave to convene a meeting under Section 210 of the Companies Act, as well as correspondingly extension of the moratorium until the end of the process in relation to the scheme meeting. And Your Honor, this is in line with the timelines that the company had anticipated back in December when it made the earlier application for an extension. And at the hearing of 17 January, Your Honor had granted extension to the 28th of February for purposes of ensuring that the company is on track in relation to its timeline. With that, Your Honor, I would like to address first the emails. The emails, we have received a total of 35 of them.
There was some more this morning. I don't think they would have been forwarded to you.
Yes, Your Honor. We have received a few just about 10 minutes ago.
Yes, all right.
Yes.
All right.
But the 35 emails was since this morning, 9 a.m. And of these 35 emails, there are 34 different creditors who have submitted emails. I think one was just from the same creditor. I just wanted to highlight that out of these creditors, not all of them are in opposition to the extension moratorium. 7 of them are actually in support of the extension moratorium. Whereas another 17, apologies, Your Honor, just let me get the numbers. Sorry, 7 of them are in support of the moratorium extension, whereas 19 of them have indicated either opposition to the extension of the moratorium, or to their support for the appointment of a liquidator. Whereas the remaining 8 creditors have just voiced concerns and queries. You know, a lot of these concerns have already been addressed in the affidavits. And I will not be able to take each individual creditor's concern in turn. But what I propose to do is to deal with them in categories. And I think the categories of concerns that have also been raised in Mr. Adamant's affidavit. And just to set a roadmap, one is in relation to the cost of liquidation, and also the comparison between a liquidation and a managed wind down. 2, in relation to certain allegations in relation to the financial situation of the company. 3, concerns about the lack of transparency of the COC members. 4, concerns about the lack of transparency, or how the company could do better in terms of communications. And 5th, in relation to the poll results, the informal poll that the company has undertaken to solicit from, or rather to elicit from the creditors their preference for 1, yes to a restructuring or no to a restructuring. And if yes to a restructuring, whether it would be any preference for a fund management or 2, a managed wind down. So these are the 5 areas of concerns. And maybe if I could start with the first one in relation to the managed wind down and liquidation and cost of liquidation. Briefly, before I get there, I think just to give a bit of context, since the last hearing on 17 January, where there was contemplation of 2 different restructuring options. 1, a fund management, where assets of the company will be placed into a fund, and any proceeds from the fund would then be distributed to the creditors. Or 2, a managed wind down, where the assets of the company will be realized and distributed to creditors. These 2 restructuring options would then also be overlaid by a reverse Dutch auction process, which basically is to give creditors the option to exit early. This was pursuant to various meetings with the Committee of Creditors, the COC. Discussions were had in terms of refining the proposed terms of the restructuring. Subsequently, then there was a town hall on the 9th of February, where the proposal for the 2 options of restructuring, managed wind down, as well as the fund management, were placed before the creditors. Apart from the town hall, there were also other COC meetings after that to explain further the proposed terms and to gather feedback and refine the terms. 2, there were also engagement with creditors. 1, in relation to creditors who had reached out individually to the company and Crow, the financial advisors. 2, the company had also reached out to the significant creditors. So the top 50 creditors by value were also invited to a separate meeting. So an opportunity was also given to them to further explain the terms. And that's because 1, the creditors are of substantial value, and therefore they would have substantial say in the restructuring process. But more importantly, many of these creditors are also influential members of the board community of creditors. And therefore it was important also that they understood what the proposed terms of restructuring are, so that then they can engage the creditors in their own discussions also amongst the creditors. There was also a creditor-only meeting on the 21st of February between the creditors and the COC. And we understand that at this meeting, a lot of the discussion was on the RDA and how the managed wind down would work. So maybe going to the managed wind down and the liquidation, if I could ask Your Honor to go with me to the 11th affidavit of Mr. Darshan Bhatia. And this is at tab 7 and page 153 onwards of the affidavit.
Hold on a moment, please.
Yes, Your Honor.
11th affidavit, was it?
That's correct.
All right. All right, tab 7.
Tab 7.
Chapter 7.
Yes, and this is the restructuring
Could I
plan.
have the page number, please?
This will be page 153, Your Honor.
153. All right, thank you.
So, Your Honor, this is the draft restructuring plan on the basis of a managed wind down that was put together by the company and its financial advisors after multiple rounds of discussions with the COC, gathering feedback from creditors at the town hall, and also from individual engagement with creditors. And this was also on the basis of a managed wind down, which I will also talk about the poll results later. But this is the preference of creditors based on informal poll that was taken by the company. And I think it's important for everyone to understand what exactly does the managed wind down option entail, because one of the allegations is that a managed wind down is no different from a liquidation, except that in a liquidation, it will be run by a court-appointed liquidator in the context of a court winding up, versus a managed wind down, which is debtor-led, which therefore means the management of the company and the scheme manager will be overseeing the scheme and the managed wind down. And I would like to, emphasize that it is different. And the very difference, apart from it being that it's different people who are running the process, more importantly, it is that it gives options to the creditors. Under a managed wind down and in the restructuring plan that's being proposed by the company, there are various points in time where creditors can choose to exit early if they wish to do so. And on this exit, they will be taking a haircut on their claims. But in exchange for a higher amount of recovery, as opposed to the other creditors who choose to stay in the scheme. If Your Honor can turn with me, so this is the restructuring plan. The first few parts just set out the background, but what I would like Your Honor to take a look at is page 154.
All right.
I will go to the timing later in the subsequent pages, but one other feature of the scheme, or the proposed scheme, is that of a one-time conversion. So the difference with our current case and other schemes is that this one here concerns claims in relation to crypto currency and various tokens. In terms of creditors' claims against the company, there are claims in source to over 250 different tokens. And because of the volatility of the tokens, there is also always that issue of whether the price goes up or price goes down. And that ties in with another allegation later, that how come the numbers always change? And I'll deal with that later, Your Honor. But because to deal with that issue and to give creditors the chance and the opportunity to select the token in which they are going to be paid in, there is going to be an opportunity for a one-time conversion of their claims into denominations of either BTC, ETH, XRP, or USDC. And this is at the bottom of page 154, Your Honor, the one-time conversion. So with that conversion, then this is basically the token that a creditor chooses to receive their distribution from the liquid assets. So under the scheme, there are also two different buckets, if I could call it. One is the liquid assets, which can be distributed. So after creditors have chosen the tokens in which they wish to be paid out the liquid assets, the claims will be converted, so will the assets be converted, and payment will be made in those assets. One thing to be clear also is that it is not that the liquid assets will only be distributed to creditors who opt into the reverse Dutch auction. And the reverse Dutch auction is where a creditor chooses to exit on the basis that they will waive their claims after taking a haircut on the claim. And this is at page 156 onwards, Your Honor, the initial debt tender offer. So what would happen is that out of the liquid assets that are available, a portion of it will be used for purposes of the RDA. And if it's successful, because there is going to be a threshold of discounts to be given, and that's over the page in 157. So what our creditor would then do is that they will say that I would like to participate, and I'm going to bid at, let's say, for example, 60% of a haircut, which therefore means they will get back 40% of their claim if they're successful in the RDA. Subsequently then, if that is successful, these creditors' claims will therefore be extinguished and they'll be paid the corresponding bidded amount of haircut. Subsequently then, the remaining claims will be paid out of the unutilized available liquid assets. And this is at the bottom of page 157 over to page 158. And for example, at the third paragraph in the first row of 158, creditors who do not participate in the RDA will then receive 23 to 34% of recoveries from the liquid assets. So it's not a situation where only creditors who participate in the RDA will recover monies at that stage. It is contemplated that there will be an RDA payment out to those who participate successfully in the RDA, to then payment of a separate portion and distributed to creditors who do not participate in the RDA. But their recovery at that stage, let's call it stage one, the initial stage, will be less than those who choose to take a haircut, have their claims extinguished. And it could be a 10% to 20% upside in this analysis here. Subsequently then, so that's in relation to the liquid assets. That then gives creditors the flexibility. Do they want to exit now? Are they willing to take the haircut? Because different creditors might have different wishes in relation to how long they want to stay in, their risk appetite. And that's because the second bucket of assets are illiquid assets. And these are assets which are receivables that the company will make 100%, will do all that it can to try to recover as soon as possible. But because there isn't a fixed timeline in which it can be received, there is a bit of uncertainty there in terms of timing and also the extent of recovery. And therefore, it's contemplated at page 158 at the bottom, subsequent debt tender offers, a similar process would then be run. So these are three of the major illiquid assets. Every time that one of the major illiquid assets are recovered, a similar process is then being run to give creditors the opportunity again to choose to exit at that point in time if they wish to do so, or get some recovery along the way. So therefore, this contemplates up to 7 times of distribution, 3 under the RDA, and 4 as general distribution to our creditors. I should also clarify that in relation to the token conversion, it's only done at the start, and that's because it can match the liquid assets that can be traded, and the assets which creditors wish to receive their claims in can then be given on that. But because the illiquid assets are primarily denominated in certain tokens, what will happen is that for the illiquid assets portion, all claims will be converted then to the currency of these particular receivables. This is to ensure that there isn't going to be too much fluctuation between the price, and there won't be fluctuation as between the claims and the assets, because then it will be stabilized. There'll be a matching of the claims and the assets in similar denominations. And when I say denominations, I mean tokens. Going to that in terms of the proposed managed wind down restructuring option, one thing that, and this is to address the concerns that have been raised in creditor emails, in the creditor emails, is that it's similar, but it's not similar. So one, in relation to the flexibility in choosing the token that they'll be paid out in, as opposed to a liquidation scenario. So in a liquidation scenario, a liquidator will have to convert everything to a single denominator and make distributions. One complication could also be what token, or sorry, not what token, but what's the mode of distribution? Is it going to be distributed in fiat currency, or is it going to be distributed in tokens? And I think that that's going to be an issue that might require directions from the court, and that's also going to take time. In terms of the conversion of all the different tokens, what is going to be the best outcome for creditors, in the view of the liquidator, and that's going to be a complex issue that needs to be resolved. Creditors will also not have to say in terms of which token they would be able to receive their distributions in, and that's a flexibility that's available to creditors in the restructuring plan. Two, in terms of timing, one of the concerns is that, or rather one of the queries raised is, isn't it going to be faster than liquidation? A liquidator can do the same thing, collect in the monies, collect in the assets and make a distribution. But we respectfully disagree. And the reason for that, it's a couple of folds. One, in relation to the claims, a liquidator can only make distributions after adjudication. And adjudication is going to take time. After a liquidator comes in, apprises himself or herself of the affairs of the company, gets familiar with the system. And what we also understand is that the system that's being used, the platform, is a bespoke system that the engineers who have been working with Vault are the ones familiar with. And in the event that they are no longer, available or employed with the company, and that's also going to be an issue because it's going to take time for a fresh set of engineers to come in, understand the thousands of lines of code, and to come up with something, create a platform for the claims and distribution, which we understand is contemplated in terms of a creation of a new system, as contemplated by the 5th to 9 parties proposed liquidator. But that's going to take time. It's going to take money. In contrast, under the restructuring plan, the intention is to make distribution as soon as possible within the first, I believe, 30 days of the scheme taking effect. And that's possible because of the way the systems are going to be used to facilitate the adjudication process. And Your Honor had previously asked, in February for us to submit a proposal of how the scheme meeting will be run, and also in terms of the voting process. One of it also is the adjudication of claims. And in that, we had proposed a streamlined process for the adjudication. And that's going to assist the whole process in making sure that things are done expeditiously. And by the time the scheme is implemented, distributions can be made on the existing platform in the token that creditors choose to receive their liquid asset distribution from in. Further, in relation to a liquidation, there are also statutory timelines. Once a liquidator is appointed, before an interim distribution can be made, a notice of intention to declare dividends need to be issued. And then subsequently, there's the claim process, the appeal process, and subsequently the declaration. And as I mentioned, Your Honor, there might be also a need for determination of the mode of distribution of the dividends. Another concern that has been raised by creditors is that the managed wind down potentially offers, or rather potentially incurs more costs than in the liquidation. And to support that, the 5th to 9 parties have put in a quotation by Contempt, their proposed liquidator, to show that in terms of the cost, it can be much lower. Two, they've also opposed or rather raised concerns about Crow's estimate of $40 million of cost in the liquidation. And perhaps to deal with that point first, it is not without basis that Crow has estimated the higher cost of liquidation. It is based on intel of liquidations that have occurred in the past in terms of how much costs have been incurred. So for example, if Your Honor could turn with me to the 11 affidavit again.
Yes,
And this is at page 114. And this is a letter in response to certain allegations and queries by a creditor. And this is one of the creditors, one of the 5 to 9 non-parties. At 1.26, Your Honor, the examples in terms of based on, so there are liquidations that Crow is not able to disclose because these are based on market intel. But more importantly, that there are examples available in the public domain. So for example, one in relation to Celsius Network, where the financial advisors sought compensation to the courts for USD 6.5 million for a 3.5 month period. That is an average of USD 1.9 million per month, or over a 3 years period, USD 67 million. 2, for Himyong, a projection of USD 12.7 million for a period of 9 months. 3, MF Global, and this is the MF Global liquidation. If Your Honor can take a look at the 4th line from the bottom, an estimate of USD 35 million for a 3-year period. And what's noteworthy is that all these, or rather some of these, especially for example, MF Global. MF Global, it was one where creditors, based on the routed article, it's only 6,000 creditors that are involved. In contrast to the present case where we are talking about 150,000 creditors. The volume of claims and also the extent of issues that need to be determined, both practical as well as legal issues, are going to be much more than all these other liquidations that have been used as a guideline in coming up with the estimate. Contempt had also put in an estimate of fees, and I don't think it's necessary to go in and break down each of them. Suffice to state that it might have, not taken into account the extent of work that is required. Whereas we have been more conservative, we meaning Bolt and Crow have been more conservative, knowing the extent of the work that needs to be done in light of the current last 7 months. Engagement with creditors, and also taking a look at the systems and the whole process. Turning to the next category, unless Your Honor has any questions in relation to the managed wind down issue.
No, that's all right. Thank you.
The next issue, Your Honor, is in relation to the financial situation of the company. So there have been concerns, and the concerns are some of them have been previously raised before. One, in relation to the state of the liquidity of the company prior to the suspension of operations on 4th of July. The holding of assets in Mr. Darshan Bashir's name. And these have already been dealt with in the affidavit, but I think I should just briefly mention them. One is that notwithstanding, so one of the issues is that why did Bolt, go into financial distress, when on 16 June 2022, Mr. Bashir had mentioned that DeFi Payments was liquid. So at that point in time, and this has been stated in the affidavit, on prior occasions, is that at that point in time, the company was still able to meet withdrawal demands. And it's only after that when the withdrawal demand escalated, whereas deposits, were declining, that's where they realized that there is an issue, and that's the reason why, in terms of liquidity, there was an issue, and a suspension of the operations on the Vault platform took place, and an application to court under Section 64 was taken out. There are various questions about expenditure, and this has already been set out in the affidavits that about 367,000 is being spent per month on operating expenses. This is basically to deal with employee costs as well as maintenance of the systems. There have also been allegations about lack of financial disclosure, but these assets and liabilities in terms of snapshots in time have already been provided at the various junctures. Of course, during the applications to court, and also at town halls and at COC meetings. There have been requests for specific timings, instead of a month end or at the relevant milestones, for example, the suspension of the operations, but they're asking for earlier timings, and that takes time and resources. And these are matters which cannot be obtained so easily because it requires time and work to do it. Whereas the focus has been in the last 5 weeks on the restructuring plan. And in terms of the important points in time, it's already been set out in the various documents and at the town halls. And to deal very briefly with the issue about why assets are held in Mr. Barcher's name, this has already been set out in the affidavit that at the time the transactions were entered into with the counterparties, there were commercial considerations in having a private individual be the counterparty as opposed to entities. But these assets are held for and on behalf of DeFi Payments. Nothing is being done without the clearance or instructions of DeFi Payments, and it's already been stated by Mr. Barcher on affidavit that he had been acting in accordance with the instructions of DeFi Payments. I should also add that to the extent possible, and in fact it has been being done, it has already been done and continue to be done, that assets in the name of Mr. Barcher's, the assets in Mr. Barcher's name are being transferred to the name of DeFi Payments to the extent that the counterparties allow for that. So this has been a process that's been being undertaken since the last couple of months. So it's not something that's new. Once we are in this process, efforts have been undertaken to move the assets back into the name of DeFi Payments. If Your Honor has no questions on this issue, I propose to move to the next.
Yes, all right, please do.
And the next area is in relation to the identities of the COC members. There have been several requests and demands to reveal the names of the COC. And this is something that we have mentioned before at the previous hearing and also in the various forums, is that we have to respect the privacy of the COC members. And to the extent that they are willing to, and a few of them have, and in fact have been actively engaging creditors on their own volition, they can do so, and they are free to do so, and we do encourage that. We are, however, not in a position as a company to reveal unilaterally the names of the COC members. And perhaps also, I should also highlight that the COC does not bind the creditors in any way. The COC does not make decisions on behalf of the creditors. The COC merely acts as a consultative body. Therefore, creditors who have concerns are free to voice them to the COC, are free to voice them to the financial advisors, and also to the company, and they will be dealt with. The COC does not bind, and when it indicates a view, it does not bind as any individual creditor. And moving to the next issue of censoring of communications. Your Honor had previously asked at the last hearing and strongly suggested that creditors forum be set up. So this has been done by way of two things. One, the reinstatement of the Telegram chat. So whilst Vault moderates that chat, I do have to highlight that the moderation is only in relation to making sure that there is no abusive behavior and there's no spamming or misinformation. Otherwise, the Telegram chat is free for creditors to use to communicate with each other. And I will deal with a few of these allegations specifically, for example, in relation to an the AMA session that was held by creditors. And if Your Honor can turn with me to apologies, Your Honor, I'm just looking for the reference to the affidavit. So this is at Mr. Barcher's 11th affidavit at page 28 onwards. So this section deals with the alleged shutting down of the communication channels. So the explanation was given in relation to the shutdown, or rather the cessation of the chat function in the Telegram chat in December. And I think that was already dealt with in the last hearing. I don't propose to go into that again. The next over the couple of pages, page 29 onwards, is that of the video recording of Ask Me Anything session, AMA session that was held by the creditors. Fiona sees what had happened was that the first message, and this is paragraph 61 at page 29, there was a message that was posted on 10th of February by one of the users called Alexi Lane. That message remains on the chat. It was not deleted. And over the page at 30, you will see that in the screenshot. The first VCA AMA Zoom webinar is available on YouTube. This is the screenshot on page 30. But shortly after that message was posted, other users started posting substantively the same message within a very short period of time. And they were picked up as typical spamming behavior because it was the same content, the same link. And therefore, these spam messages were therefore removed to reduce spam in the chat group. The first message was not deleted at all. It remains there available for everyone to take a look at. And if I go over the page, there was a separate link that was posted and that was not deleted. So it's only in relation to the same link, same content, that spam was removed from Telegram chat. There have also been examples of abusive behavior, messages in terms of statements that have been made that are quite derogatory and abusive. Your Honor will be able to see that at tab 4 of the affidavit. And that's the reason why VOD had to step in to moderate. And these are examples at tab 4, Your Honor. Your Honor, would you like to go to those, or it's not necessary? Great, Your Honor. So therefore, to sum up on this point, it's not that we are trying to stifle communications. It's far from that. The censorship, the purported censorship only is to ensure that there is no abusive behavior, there is no spam, so that it can create a forum for constructive discussion amongst the creditors. And what I'll do then is to turn to the next issue in relation to the informal poll. So a lot of the concerns that have been raised in the emails is that the informal poll that was taken by the company is not indicative of support for the managed wind down proposal. And that's because an allegation has been made that the informal poll is biased because it did not reflect a liquidation option. And that's not true, Your Honor. If Your Honor can take a look at the poll, and this is that the 10th affidavit of Mr. Darshan Bhatia, filed on the 21st of February. And I'll show Your Honor a sample of the poll questionnaire. Apologies, Your Honor, you're on mute, but I think you're asking.
Sorry, what page? Sorry.
236, Your Honor.
236.
So the reason why we did the poll was to get a sense of creditors' preference. We heard Your Honor's suggestion at the last hearing that creditors be presented with the options and will be allowed to vote. And we thought about the best process and the most efficient way to do it. Do we want to do it at the scheme meeting itself, or do we want to do it earlier? And we didn't feel that doing it later would be efficient, both from a cost and time perspective. And therefore, we thought that we do it on an informal basis to get a sense from the creditors what it is that they want, so that then time and effort can be spent in refining the proposal based on the creditor's preference, And therefore, when we make the application for leave to convene a scheme meeting, there will only be one restructuring proposal for creditors to vote on. This is to ensure there is minimal confusion or no confusion at all in terms of what the company is proposing. And what had happened is that following the hearing on 17 January, we engaged with the COC with various creditors. We prepared slide decks. So there was a slide presentation for the town hall on 9 of February. This was a session to explain to creditors what the two options were, to take in questions and also to deal with any other concerns that creditors may have. And a poll was then issued by way of an email. So on page 236, that's the email that went out to creditors to ask them, for their preference on the preferred recovery option. Over the page is a sample of the vote form. If your honor can go to page 238. The voting questions are that of whether a creditor is for or against. So it wasn't a situation where we're only asking, do you want to manage wind down or do you want a fund management option? We had asked two questions first. The first question is, are you for or against restructuring? Two, if you are for restructuring, you support that, what preference do you have, if any? Fund management or a managed wind down, or you have no preference at all? Those were the options that were clearly explained to creditors, and that was set out in the informal poll. So it wasn't biased. If a creditor was against restructuring, they could have voted against. And in fact, 14% of the creditors who voted had said no to a restructuring. Another allegation is that only 1,525 creditors had voted, and that only represents about 1% of the entire creditor body, and therefore not representative. We beg to differ, Your Honor, because the very fact that over 1,000 creditors who actually came forward to actually indicate it's already very positive that there are creditors who are participating actively. And this also is reflective of potentially the universe of creditors who would attend a scheme meeting and would vote.
I'm not sure about that, Counsel, but in any event, isn't 1,000 really a very, very small proportion?
Yes, sir. I do appreciate that 1,500 is basically 1% of the entire universe of creditors. But we also have to bear in mind that a lot of these creditors might not be interested. They might be willing to just go with whatever the majority of creditors or the more active creditors are interested in. And that's because many of them actually hold very small amounts. Perhaps my colleague can help me find a reference, but there is a reference in an affidavit that talks about how I think about 50% of creditors have less than $50 USD in claim value. So it could very well be the case that a lot of them are not interested. They are happy to be bound by whatever it is. And it's not a situation where they're not informed. They have been given many opportunities to come forward if they wish to. And it could very well be that for whatever reasons, they are just not interested, or they are happy to be bound by the process.
All right, please. Yes.
In contrast, Your Honor, perhaps I can just also deal with the point that the VCA, so the 5th to the 9 parties, they have stated that they have a group of about 250 members in the VCA, and they have said that it's equivalent to about $50 million in assets. I just wanted to emphasize certain things, that it does not mean that all 250 members support or don't support the VCA's views, and that's because, as we understand it, the 250 members, when they signed up, they just wanted to be kept informed. So this is if I could ask Your Honor to go with me to the 11 affidavit of Mr. Darshan Bashir again. And this is tab 1 at page 53. This is the sign-up page on the VCA. So it's the Vote Creditors Alliance that's being created by the 5th to the 9 parties. The sign up page, join VCA and sign up for email updates. All I simply ask is that join the VCA to receive updates on the board restructuring by email. There's nothing in there that suggests that if you're a member of the VCA, you are already taking a certain view. It's just for informative purposes. And a creditor, could possibly want to sign up just so that they can get information, but it doesn't mean that all of them agree with the views of the 5th to the 9th parties. Furthermore, it is not clear also whether all 250 of them are indeed creditors of the company and whether indeed the $15 million value of assets is really true. There is no way of verifying that. This is just simply based on the sign-up sheet at page 53, simply that a value is being provided by each of the creditor who wishes to sign up. And we do not know whether they're fictitious, real, and what exactly the real value if they are a real creditor for. And Your Honor, we can go to the poll results. And this will be at the 10th affidavit of Mr. Bhatia. And this is tabulated at tab 10, and this is page 241 of the affidavit.
Yes.
Yes, Your Honor. So a total of 1,305 creditors out of the 1,525 respondents have indicated a support for restructuring. And these 1,305 creditors total an amount of about USD 117 million in value. Out of the substantial creditors. So in contrast, in contrast with the VCA, the 5 creditors, the 5th to the 9th parties, they have about total of 3.5 million USD in claims, who are in opposition of the restructuring. We also understand that based on the responses that were received, only 2 out of the top 20 creditors in terms of value, or if we look at the top 50, 6 out of the top 50 creditors oppose restructuring. And I think at this point, perhaps I can also deal with the point that an allegation that's been made by the 59 parties that it's a very complex scheme with the RVAs. Creditors don't understand, they are not making an informed decision. I think that's where I do find that I have to explain that it is not the case. There have been various forums, both at the COC and creditors only forum, 2 at the town halls, 2 at the sessions between the company and select groups of creditors, where the scheme has been explained and creditors do understand. And this also has been acknowledged by the COC. So on the 23rd of Feb at the COC meeting, the COC members all have confirmed that they understood the terms of the scheme and are generally in support of the scheme. And these, I should say, are the members who attended the meeting on the 23rd of February. And there were 9 of them. And perhaps since I'm on this issue about support, we also have support for the extension of the moratorium from 15 COC members representing 11% of the claims. And this is in addition to the other creditors who support the moratorium from the creditor emails that the court has received. And 2 also based on the response from the creditors, the 1,305 creditors want support a restructuring. The necessary inference is also that they are supportive of the extension of the moratorium to be able to bring the restructuring to the end. And with that, I should also highlight that the timelines have also been made known to creditors at every stage. So at the last hearing and also at the town halls, creditors are aware that to get to the restructuring plan, time is going to be needed to put together the explanatory statement and the scheme, and for the application to be made and for it to be heard. And that's all set out in the affidavits. I think with that, I have just one more point that I have before I just sum up, is that the company has been, forthcoming with its plans and progress in the restructuring. It has been unfortunate that the proposed Nexo acquisition didn't happen for reasons that were already discussed at the last hearing. I don't propose to go into that. But at that point in time when it failed, when it did not proceed, it wasn't a situation where the company came up with new ideas. The proposed restructuring in relation to the fund management has always been an option. It just wasn't pushed forward because efforts were focused on the Nexo acquisition. And now when that failed, it went into overdrive, in making sure that we had the proposed fund managers lined up. There were various interviews with the fund managers that were undertaken, engagements with creditors to understand what it is that they wanted. And it is quite fortunate that we are at this point in time now able to say that we have managed to get to a point where we have taken into account creditors' preference. The company has heard the voices of the creditors. We understand that the majority of them, a good number of them, want managed wind down, and that's the proposal that's being put forward. There's also an intention to ensure that there is going to be less of fluctuation between claims and assets. So as I mentioned to Your Honor earlier, the numbers appear to be moving, but that's always because of the fluctuations in token prices. And perhaps I can just go into a bit of detail on that. And this is at Mr. Darshan's 11 affidavit, paragraph 95. And this,
Yes.
yeah, and this is at page 45. Sorry, and maybe before that, if we could go to the page 43.
All right.
So this is paragraph 91 onwards. So the company is also, mindful that there is an asset liability mismatch because of the tokens volatility in terms of prices, and there is a mismatch in terms of the value of claims in tokens versus stable coins in both claims and assets. And so that's the reason why Defi Payments also intends to take certain steps to ensure a better asset liability match. And this is set out from paragraphs 91 onwards to paragraph 95. So the intention is to actually trade the liquid portion of the cryptocurrency to broadly match the composition of the customer liabilities. And this is to ensure that there is not going to be a great differential in terms of asset liability mismatch, that every time we come back to court or we come back to creditors, there's always that difference in numbers. But before the company actually undertakes this exercise, it wishes to inform the court as well as creditors of it. So there is transparency, and there's upfront transparency on what the company intends to do in the whole restructuring process. And this is also a forum where we invite creditors to let us know whether they have any concerns so that they can be taken on board. Although at the starting point, the company is not prohibited from doing so, the company wishes to take on board creditors' concerns, if any. So this is reflective of the efforts, the intentions of the company, in the whole of the restructuring process. As much as we can, we want to engage, and we have been engaging creditors on the whole issue. And so with that, Your Honor, I just wanted to sum up in terms of the requirements that I have to satisfy Your Honor today. One, in terms of bona fide efforts, and I think based on what I've mentioned earlier in terms of the steps that the company has taken since the last hearing, and we are on schedule based on the previous estimate in terms of timelines. We have engaged creditors substantively, and to ensure that we understand the preference, and we have in fact prepared a draft restructuring plan that I showed Your Honor earlier. And this will form the basis of the scheme of arrangement, subject to any further refinements with pursuant to any discussions with the COC or the creditors. Two, that the plan has a reasonable prospect of working and being acceptable to the general run of creditors. The plan is not the same as a liquidation. There is a proper scheme. There is a flexibility that's given to creditors in terms of timing and token for distribution. Timeline-wise, it's also generally faster. And so the main thing is that of flexibility. Flexibility of timing, flexibility in terms of the token conversion. And this is something that will not be available in a liquidation. It also has a reasonable prospect of being acceptable to the general run of creditors based on the poll that I brought Your Honor through. Majority of the creditors are in support of the restructuring, and I should say the creditors who have responded to the poll. But that is in our submission an indication of the general run of creditors and the creditors who would vote at the scheme meeting, if Your Honor will grant leave at the appropriate stage. And with that, Your Honor, I turned briefly to the application for leave.
Yes, before that though, could you just summarize for the record and those perhaps observing the broad outline of the next steps to be taken, the timeline basically?
Yes, Your Honor, perhaps with that, I could show Your Honor the timeline, and this is set out at the 10th affidavit at page 26. This is paragraph 43.
Yes.
Yes, Your Honor. And this is similar to the previous timeline that we had set out in the 8th affidavit and was discussed at the last hearing, is that we are on track to prepare, finalize, and issue, prepare and finalize the explanatory statement and the scheme of arrangement. And we propose, and we will do that on the basis of the draft restructuring plan that I brought Your Honor through in the course of March. And we are looking to apply to court for leave to convene a meeting of creditors, and also correspondingly a further moratorium extension to facilitate the scheme meeting process in April. And this ties in with our summons that we're asking for extension to the 28th of April. I am conscious that in terms of the timing, that would then require us to file an application, not end of April, Your Honor, but early April, so that there will be sufficient time for affidavits to be filed, submissions to be made, and for a hearing of the Section 210 application and a corresponding extension application, extension of the moratorium application by the end of April, which is 28th of April, as we've asked.
All right. I think I've actually expressed previously that I would have to go through the scheme meeting arrangements if we get that far, but could I also ask you at this point to indicate to me what you envisage the streamlined proof of debt process?
Yes, Your Honor. So two things. One, and that's set out in our 10th of February letter. What we propose in relation to the scheme meeting, as well as the voting, as well as the claim process, is that instead of a physical scheme meeting, which is of course not going to be very possible in this case, we are proposing that it be split into two sections. One, a virtual meeting, and this virtual meeting will be where it will be like an information session where the company will explain the arrangement, the scheme of arrangement. And before the actual meeting itself, a notice of meeting will be issued. Questions will be invited as well. So we will invite creditors to submit questions in advance of the virtual meeting. At the virtual meeting then, we will explain and also take questions, and also open a voting process. So it will not be a situation where creditors are required to vote at the end of the virtual meeting, but it will be that creditors will vote electronically after a voting period of time. So that's in relation to the vote and the scheme meeting. Two, in relation to the claims process. The streamlined process that we have in mind, Your Honor, is that instead of the usual process where we invite proofs of debt to be submitted by creditors, and we only adjudicate that universe of proof of debts, it will be done the other way around. When we issue the notice of the intended scheme, creditors will also be informed in the same document of their claim amount based on the vault platform. And that's because as a starting point, these creditors would have claims in relation to the account balances on the vault platform. And we will be using this as the basis to send it out to creditors to say that this is the claim amount as determined by the company. Creditors will then have the opportunity to dispute the amount if they have any. What would then happen instead of under the traditional scheme process where each individual dispute will be adjudicated separately by various independent assessors to be appointed in each individual dispute. What we propose is for the court to appoint a single independent assessor to deal with any and all disputes that may arise.
All right. You're not proposing to deem agreement for small values?
Yes, Your Honor, we are contemplating that, and we have heard, or rather we have seen Your Honor's comments, in one of the other decisions. And how we intend to deal with it, Your Honor, here is that to actually go with the traditional scheme process. So we do understand that in that other matter, it was in the context of a pre-pack scheme. But what we are hoping to do here, because we do understand there are challenges, it's not provided for in the context of the order, in terms of a jurisdiction to create a separate category of claims. And therefore, how we propose to deal with it is by way of a streamlined process for adjudication of claims, and to go by way of the traditional scheme meeting route.
Right.
And to give basically creditors the opportunity to come forward if they wish to, even though they are small creditor. And maybe not that, I should just emphasize also that it's under the scheme that small creditors have an opportunity to still get paid, as opposed to potentially in a liquidation where a new system needs to be set up, or fiat currency is going to be used to make payment. And there are possibly going to be issues about payment because there might not be a bank account that's available by the creditor because it's a foreign creditor. And the only way to make payment is by way of by a TT transfer. And that's going to incur quite a significant amount of costs. Administratively, I think it's about $20 for the very least. And that might already eat into or diminish or deplete entirely the distribution. And therefore, small value creditors might not even get a single cent in terms of distribution. Whereas under our proposal, because we are going to use the existing vault platform to make payments out to the wallets of creditors on the vault platform, small amounts can still be redrawn from the vault platform by these creditors.
All right. Thank you, Ms. Ng. Anything further at this time?
Not at this time, Your Honor. Maybe just going to the application for leave.
All right. All right, I'll let you address it at this point, and of course, we'll then turn to, Mr. Chua. All right.
Yes, Your Honor. Perhaps just very briefly on this, it's that we are asking that, it be dismissed for the reasons that it is disruptive and doesn't add any purpose. And the reason for that, Your Honor, is that the summons asks for leave to file an application for winding up, which therefore means that it's only going to be filed and the stay will still be in effect. And with the stay still in effect, all it simply does is that there is going to be out there that there is a winding up application that's pending without any timelines that are moving. So it doesn't save time. Instead, it is going to cause confusion. Creditors will be wondering, why is there now a winding up application? What's happening here? And it's not a situation where the restructuring process is only a restructuring process and creditors are required to, participate in the restructuring. They are free to oppose. And if they oppose, and if in the unfortunate event that we don't succeed in the restructuring and Your Honor doesn't grant us leave or approval at whichever stage, at that point in time, Your Honor, in my submission, will be the appropriate time for then the companies to also consider what are the next steps, liquidation or not. And that's where creditors who wish to file an application can also do so at that point in time. There is no prejudice cost that would be caused to the fifth and the ninth parties.
All right, anything else?
That's all for now, Your Honor. Grateful.
All right, thank you. Mr. Chua.
Yes, Your Honor, I'm grateful. Your Honor, I appreciate you read my submission. So I like to focus on a few key points. Your Honor, this is an application for an extension of the ERDA moratorium. And so generally, when the court hears the first application, court considers whether the plan is feasible, merits consideration by creditors. At that stage, generally, the court doesn't take a close scrutiny because usually the plan is nascent. But with multiple extensions and when the company has had enough time to formulate the plans and gone through options, my submission is that threshold of scrutiny should go up and you should more closely analyze it when it's gone through development and the plans are clear. And that's the case here, Your Honor, because it's been 7 months since Your Honor first granted the moratorium, or rather 7 months since the application was filed and the moratorium kicked in. And so the company's restructuring options, Your Honor is very well aware, have been whittled down. It can't be rehabilitated as a going concern, that's off. Attempts to find a buyer, that's failed. Creditors have no interest in taking further risk with a speculative fund manager option. And we're really down to recovery and distribution of the company's available assets. So in short, really the restructuring plan that's being put forward, couched as a MWD, is really a liquidation, but the company wants to control that process. So my submission is the question here really is this the kind of scheme that passes the statutory test of feasibility and meriting consideration by creditors? So put another way, is this scheme really going to be delivering a better outcome for creditors compared to a court-ordered liquidation? And we say no. When an insolvent company is looking to recover assets and repay assets creditors, and at the end of that dissolve, the default process should be the statutory liquidation process. That's well understood. It's provided by statute. It treats all creditors fairly. And if an insolvent company wants to use another process to achieve really what is the same outcome, it must have compelling reason to do so. I will show Your Honor that that's not been done. They haven't offered that compelling reason. Your Honor, what I propose to do now is really go through some of the a comparison exercise, if you like, between their scheme and the liquidation. And I'd like to show Your Honor how this has been marketed to creditors as well, the pros and cons. In a nutshell, creditors are being told that compared to the managed wind down process, a liquidation is going to cost more, it's going to result in lower recoveries, and it's going to take a longer time for creditors to get a payout. I'm sorry, but that is very misleading. And that's not a fair presentation at all of the pros and cons of the two options. Could I maybe just to make the presentation clearer, I ask Your Honor to pick up Mr. Darshan Bhattacharya's 10th affidavit. I want to direct Your Honor to the slides that were presented by Crow at a town hall on the 9th of February. That was the most recent town hall.
All right.
And it's at page 178, Your Honor. That's the first page of that presentation.
Yes, thank you.
And could I just ask Your Honor to scroll down to page 185 first?
185, all right.
185, that's right. The slide is titled Liquidation, Practical Outcomes of a Liquidation of DeFi Payments. I won't read through all of it, but this is essentially Kroll's summary of what would entail, what would happen in the liquidation. Your Honor will see, talks about how vault management displays won't play an active role in asset recovery efforts. They talk about uncertainty of timing, and they give various reasons why they say it will take up to a year. They talk about higher expected costs, and that's where that USD 40 million number then comes in. That's the third bullet point. I'll come to that shortly. They talk also about how assets will be converted to fiat, and then they talk about how smaller creditors comprising about 50% who are owed $50 or less, are going to be disadvantaged. Can I then ask Your Honor also to look at page 186? Just the next slide.
Yes.
And this is Kroll's forecast of what creditors are likely to receive in a liquidation. Maybe I give Your Honor a bit more context for the slide. So the first line item at the top, opening asset balance, you see a number of 115,287. Those are the liquid assets that are ready for immediate distribution. And then under the second line, asset recoveries are the illiquid assets. Those are the flip vote receivable, the counterparty A loan, and I think one other loan with coin loan. So those are the three buckets of receivables. And you want to see how they've compared this between a fund. I'm taking this slide. This slide shows the forecast between a funds under management option, that's the fund manager option, and the liquidation option. It compares that. The funds under management option is on the second column, and then liquidation outcomes extreme right. If I can just sum this up very quickly, Your Honor, what this slide purports to show is that in a liquidation or in a funds under management scenario, creditors could get back 83%. In a liquidation scenario, that goes down to 64%. And Your Honor can take it from me, the reason for that difference, there are three reasons. One is there is expected to be an impairment of one of the receivables, the flip book receivables in liquidation. So they take out 20 million from there. That's the third column, Your Honor. You see impairment of flip book receivable. And then they also say the second reason for the lower recovery in liquidation is because they say in a liquidation, the cost will be 40 million, which is 32 million more than in a funds under management scenario. And then there's also going to be some gains from the fund manager coming in and managing those balance funds. That's about 11 million, about 3%. Now, if you take away the funds under management gains, that 3%, you're really talking then about a managed wind down. And if you look at the comparison then, if you take out that 3%, it's really 80% versus 64%. But what I'm going to show you, Your Honor, is that there's no basis to impair that flip vote receivable in a liquidation, even based on their own case. And there's no basis for Kroll's to estimate that cost in liquidation will be 40 million. So if you take away the 20 million impairment of flip vote and the $40 million in cost for liquidation, you really get down to the same, exactly the same recovery prospects in a liquidation versus a managed wind down. So let me just deal first with the cost of the liquidation, this 40 million number that creditors are being scared with. Your Honor will have seen that Kroll slide, that I'm sorry, at page 185 of that slide. The reason Kroll says this number is based on 8 similar insolvencies, and we're now given to understand that at least some of these insolvencies include Hin Leong, Celsius, and MF Global, and that's where they got that point of reference and worked that estimate. To me, I'm actually quite troubled that they're using these insolvencies as a point of reference here. Your Honor is well aware of the publicity around these insolvencies. They're quite well reported. Hin Leong is Singapore's largest corporate fraud to date. There's $4 billion worth of debt. You're talking about fictitious documents being generated, fake accounts, etc. There are criminal prosecutions going, and it's got nothing to do with crypto. Celsius is one of the largest crypto platforms in the world. The debt's there. It's a US insolvency. That's more than 4 billion from what I can tell from my own research. And it's a platform that claimed at one time to have more than 1.7 million customers. And in the US bankruptcy, I see now from press reports that it's facing allegations it was running a Ponzi scheme and fraud. And finally, MF Global, Your Honor, that's a global financial derivatives broker regulated in multiple jurisdictions with debts in the billions. It was found to have commingled customer and company funds. It was paying fines to the SEC left, right, and center. How can these be appropriate points of reference for this particular case when there are 300 plus million liabilities, there are assets of about 115, and we're told that recovery could be up to 80%. And we're told that the books are fine. They're all in order. Everything's being kept in a proper state. So I would ask Your Honor to disregard that 40 million number entirely. And Your Honor will see that Kroll have not given their own estimate, given their 7 months experience of what they say this insolvency would cost.
All right.
They're relying on other, sorry. Your Honor.
Sorry, Mr. Chairman, apologies, could I just stand down for about 5 minutes at this point?
Of course, sir.
And
Of
we'll
course.
resume shortly. Right.
Yes.
All right, Annie, we'll stand down for a short while.
What is the agenda? The hearing will resume now.
All right, thank you, Mr. Chua. Let's
Yes, Your
continue. Thank you.
Thank you, Your Honor. Your Honor, before the break, I was addressing you. I was talking about the 40 million cost estimate from Kroll for liquidation. And I was saying that's a figure that's it's way out of whack. I wanted then to show Your Honor the Corda Mentor proposal for this liquidation, assuming order is made. And that can be found in Mr. Jonathan Edelman's affidavit at page 173. And if Your Honor has that, 173 is the first page. It's a specific proposal that Corda Mentor had given to the Vault Creditors Alliance. And can I just preface that by saying their credentials, their Corda Mentor have directly relevant experience in crypto insolvencies. They know what's involved, they know what is required, and they've given their own estimate of the likely costs based on information provided from them, of course, and the information about this particular case that is available. Their estimate is 7.5 Singapore dollars, 7.5 million Singapore dollars, or USD 5 million. Okay. And I'll show you what that includes. You'll find that at page 182, where they give a breakdown. So Your Honor will see at page 182, that's the estimate, and that estimate includes their fees. It includes digital asset custodian fees for the transfer of crypto to a third-party custodian. It includes legal fees, includes disbursements, includes the retention cost of key employees to assist liquidators for a short time, and ongoing software and maintenance. So in essence, this assumes that they will be coming in, running a crypto platform, making sure assets are properly maintained and recorded. Everything that it would appear the company is expecting to do in their MWD. Now, one of the points that my learned friend made, and it's also a feature of their submissions, is, look, if if somebody else comes in, a liquidator comes in, the vault management is displaced, they won't actively participate, you have to start getting new infrastructure, you start again. My short response to that, Your Honor, is this. Number one, Mr. Darshan has been very clear in his affidavits to this court to say his interests are to make sure creditors get full recovery. He's got their interests in mind. Secondly, we're going to assume that the books and records have been properly maintained and business practices were proper. Thirdly, a liquidator coming in is entitled to cooperation from directors. They may not be enthusiastic, but we don't need their enthusiasm. We need their cooperation, and we can compel that if they refuse to give it. And I also point out, Your Honor, that Kroll themselves, and I won't bother Your Honor to turn up the meeting notes, in one of the COC meetings, Kroll themselves have said there's no reason to expect that Mr. Darshan or Mr. Sanju, the key management, will not work closely with liquidator. Perhaps I'll just give Your Honor that reference, and I won't bother you to turn it up. It's in Mr. Darshan's 11th affidavit at page 80. Those were the minutes of a COC meeting where that comment was made by Kroll. As far as the vault architecture is concerned, the platform, there's again no reason why a liquidator cannot retain that original system or retain key employees who understand that system and that platform. A liquidator doesn't need to fire everybody on day one. You can even carry on business for a minimum of 4 weeks, rather a maximum of 4 weeks, without authorization from the court or the Committee of Creditors. And if a further period is required to bed in the liquidators, that can always be, that authority can always be sought. So you don't throw away all the institutional knowledge acquired on day one of a liquidation if it doesn't make sense. There's also a stray comment in one of Mr. Darshan's affidavits when he was trying to say a liquidation would be more complex, etc., is that they'll need to do KYC if the liquidators come in. I don't quite understand that. There's no legal requirement in the liquidation for a liquidator to do KYC. But again, this comes back to the point about us assuming Vault has run their business properly. Because if one assumes that they've already done their own KYC when they onboarded the customer, I don't see why a liquidator can't just take on those same results or rely on that information. And finally, of course, Your Honor, the one feature that is absent from the scheme process in terms of fees is a liquidator's fees are subject to control and scrutiny, not just by creditors, but ultimately by the court. Every cent they're going to have to justify to the court, and they can expect close scrutiny, and they're going to present a $40 million USD bill. I think they can expect to get a robust inquiry from the court. So that's on cost, Your Honor. It's just not correct for Kroll, for the company to present the cost in liquidation as higher or even exponentially higher, could even be lower. I then turn to recovery prospects because, as I said, it's been presented that it's going to cost more, you possibly get back less. So on recovery, when we talk about recovery, we're only talking about the illiquid assets, and those are the three receivables. And Your Honor would have seen earlier, maybe if I can trouble Your Honor to go back to Mr. Darshan's 10th affidavit again at page 186.
Yes, sorry.
Yes, Your Honor. So Your Honor, recall that I pointed out the only receivable that has been identified as potentially being impaired in a liquidation as compared to a managed wind down is the flip vote receivable. Your Honor may have some recollection of this receivable. It's basically funds stuck with DeFi, the Vault Group's Indian subsidiary in India, flip vote. It's about 20 million USD. Appears that that is a sum that's been that is due from flip vote to DeFi Payments as a receivable. And the reason it's stuck presently is because the Indian authorities have frozen flipvote's accounts on account of some money laundering concerns of one of their customers. So I will come to that in a bit more detail later, Your Honor. There's some troubling aspects about this. But for present purposes, if we're talking about recovery, I don't see why a liquidation would cause the recovery of this receivable to be made more difficult. Because the recovery should be the same. If this is essentially a legal issue that's being handled by Indian lawyers, a liquidator comes in, the analysis is still the same. We're still dealing with Indian lawyers and relying on their advice to deal with the Indian authorities to get these funds released. The legal merits of that case does not change. Now, it's been suggested that in a liquidation, Vault's management will somehow take a less active role, and that may have an impact on recovery. But why, Your Honor? If their role and their participation is required in order to ensure this receivable is recovered, they should cooperate, and they don't, as I said, the liquidator can compel them to do so. Here, Your Honor, can I also just deal very briefly with a point that was made by Mr. Darshan in his 11th affidavit as potentially also affecting the recovery prospects. What he says in that 11th affidavit at paragraph 88 is that liquidation may trigger events of defaults under contracts. Now, my learned friend didn't say that, didn't rely on that as something you should take into account. But just very quickly, if that really is a concern that liquidation is going to trigger EOD events under contracts, Your Honor is familiar with these standard EOD clauses in loan agreements. If they have been triggered, they've probably been triggered already by the filing of the moratorium proceedings. And we're not told what these contracts are anymore. So that's recovery, Your Honor. Again, I would say there's no basis for Kroll or the company to assume recovery will be anyway reduced in the liquidation. It should be exactly the same as a managed wind down. Then we come to timing, Your Honor. The promise being held out to creditors here is in a managed wind down, you'll get your money back faster. A liquidation is going to take very long. There are timelines the liquidator has to comply with. But I think let's look at the flip side of the coin. A scheme is not necessarily any faster. And I think the complexities in this scheme in particular, and in running the scheme, have been actually quite significantly underplayed. So let's take a look firstly at the entire timeline. You first have to apply for leave to convene a meeting. You've got to convene that meeting, send out a statement, send out notices, invite proofs. I know there's talk about how they're going to be running that proof process, but there's got to be a process for adjudication, for resolution of disputes before an IA, and those are statutory timelines. And then you call the meeting, and as far as the meeting is concerned, I can immediately see a number of issues that may come up in terms of classification. The first is, Your Honor, if this scheme is going to provide for small creditors to be paid off in full, you're then talking about two-class scheme, not just one. And secondly, if you're talking about voting in this scheme, issues as to discounted voting may also have to come in play. Why do I say that, Your Honor? Because most of the creditors in the scheme will be people simply holding with deposits on the Vote platform. They've got an app. We understand that Mr. Darshan, as well as other members of management, are also creditors. They also have accounts with Vote. Now, the question then is, can these parties really be voting, or can the votes of these parties really be ascribed the same weight as all other creditors? I think there's a serious question mark there, because these parties have access to much better information about the company state, about receivables, about the recovery prospects for those receivables. Can they really be given 100% on their vote? And that is an issue that is, I think, very likely to come up in a scheme that is being proposed here. And as Yona knows, the question of how we discount the votes of related parties is something that's still in development in Singapore. It's not a straightforward question. And then when we get, even if you surmount all these hurdles, you get to the stage of the meeting, you hold it, it's passed, we come to sanction and implementation. And when we come to implementation, the way it was originally presented at the 9 February town hall to creditors was that only those who participate in the reverse Dutch auctions will get an earlier distribution. Now, I'll make good that point later. When I come to the RDAs, because it's quite a troubling feature. And those who choose not to do so, it was presented at 9 February, will actually have to wait. They wait to the end. Now, that's not so with a liquidation. All of these pitfalls I've mentioned don't arise. The statutory process is clear. There's recourse to the court at every stage. The directions are required. And if one assumes, Your Honor, just for the sake of argument, that a liquidation order is, say, made today, liquidator comes in, receives full cooperation, assuming all books are in order and management cooperates, it's not inconceivable that it could well be an interim distribution of the liquid assets to all creditors within 2023. And that is really not a materially different outcome from a scheme scenario. Your Honor, can I then come to this question of the RDAs, because they are really the central feature of the managed minority. In my submission, it's really the only thing that makes it stand out from the liquidation process. And here, I ask Your Honor to turn back to Mr. Darshan's 10th affidavit again, back to the Kroll slide decks at page 222 of that affidavit.
Yes.
Yes, Your Honor. So I've brought Your Honor to this slide because I wanted to, just again, these slides were presented to creditors at the town hall on 9 February 2023. And I wanted to show Your Honor how the RDA, when they're going to get payment, how it works, has been presented to creditors. And this is how the RDA works. If Your Honor sees the first RDA, I'm sorry, maybe I should do this more clearly. If Your Honor looks somewhere in the fifth line of that spreadsheet, you want to see RDA final distributions.
Mm-hmm.
And if you look straight all the way across, you'll see that in 2023 third quarter, there's going to be a RDA distribution of 50 million.
Mm-hmm.
And then in 2024 second quarter, 20 million. And then in 2024 third quarter, 107 million. So basically, and you look down the column to extinguish liabilities.
Mm-hmm.
So for 2023 third quarter, the RDA amount of 50 million will be used to extinguish liabilities of 125 million.
Mm-hmm.
And if you go further down, it means that creditors who take up their RDA at that point will get 40% on their claims. And you can apply that same logic to the other two RDAs. If you exit later, when the amounts being used to extinguish liabilities are smaller, you get a bigger return. And if you stay the course all the way, and Yona goes all the way through to the second last column, 2026, second quarter, you see that distribution then will be 85. And if you go all the way down, that could translate to a recovery for those creditors who stay at the cost of 142%, meaning they get more than their claim. It's just a couple of points I want to make about this, Yona. The first is this. The way this was presented to creditors on the 9th of February was only those who take up the RDA will get a payout at that point in time. Creditors who choose to stay out don't get any payment. I hear from my learned friend today that that's now changed. It seems that creditors who don't participate in RDA will also get a payout at the same time, but of a reduced amount. But this is not what creditors were told on the 9th of February, as you can see from this spreadsheet. That's the first point. The second point is really my main one, and that's that this system is really grossly unfair, particularly given the creditor profile we have here. You've got 150,000 plus people across various geographies with vastly differing claim amounts and really vastly differing financial sophistication. The poor guy with $50 still stuck in his wallet, he's not going to be as interested or even bother to try and understand this process as much as someone who's got 50 million stuck. So what the RDAs really do, they're structured that way is they discriminate against those who are less savvy, who are more desperate for the funds, and more importantly, who have less information about the liquid assets, the illiquid assets. That's actually very important, because if I give you an example, let's say a creditor is at the first RDA, he's deciding whether or not to take his chance and participate and take a haircut on the first RDA. What does he need to know in order to make a fully informed decision? He needs to make an assessment as to how likely it is the illiquid assets will be recovered. If the assessment is, look, they're all gone, counterparty A is insolvent, we're never going to get money back, it makes sense for him to take it now. 40% is a good recovery. On the other hand, if he knows that it's just a matter of time, he will get money back eventually, he stays. And in fact, he's motivated to make sure more people participate in RDA, so he's got more potentially making a gain at the end. But what information do the general run of creditors have about the liquid assets? Frankly, nothing, Your Honor. All they know about counterparty A is that there's 106 million that's potentially coming back. They don't know the identity of the counterparty. They don't have any access to the contractual documents. All they are told are in these slides that there's a significant potential for disputes and possibility of defaults based on loan documents. How do you make an assessment based on that? And the other troubling feature of that information asymmetry is it actually favors insiders. I mentioned earlier that Mr. Darshan, Mr. Sanju, senior management, they have accounts with all, presumably they have money stuck there. They have friends, they have families. And you've got COC members, these 30 of them, who are getting access to more information because they get regular briefings. All of them have a better insight into these receivables. And so it really comes to this, Your Honor. The way this is set up, the way the RDAs are structured, you could very well have a scenario where 125 million worth of debts are compromised at the first RDA. people are scared. They say, let's take the money, and they bail out. At the end of the liquidation, that process 2 years ago, people find out some people have actually made 142% of their money. They made a gain because they stayed the course. You're going to really then have at that stage a potential for further litigation. People are going to complain that I didn't know, you didn't tell me. And is that really the ideal outcome, to have this dragged out in that manner? And of course, the converse is also true. Some could bail out earlier knowing that the illiquid assets are irrecoverable. And then they get 40% more, 40% recovery, and those who stay to the end get 27%. Again, the potential for dispute, for litigation, it's quite real. Now, Ms. Ng had said, look, it's a structure of this, it's a feature of this scheme. We've explained it to creditors and they understand it. So the suggestion is that we are making too much of this creditor ignorance about how this actually works. And here, can I just ask Your Honor to pick up Mr. Darshan's 11th affidavit? And could I invite Your Honor to go to page 95? Just for context, Your Honor, perhaps could start at page 94. These are the minutes of a meeting, a COC meeting that was held on the 17th of February.
Mhm.
And if you go to the next page, Your Honor, page 95, if you go some way down towards the bottom of the page, somebody called AB is making a comment. Does Your Honor see that? AB regarding just RDA1?
Yes.
And the comment that he makes, this creditor, is regarding just RDA1, the initial RDA. I think you should have more than one round. You should have one more round of voting. What I feel from all creditors is that they don't have much knowledge of an RDA. In your result, it shows 42%, not even 50%. Everybody thought that if you do an RDA, they will get a minimum 40%. These are the words of a COC member, someone who is well informed. He himself is saying creditors don't actually understand this. That's his comment. And Ms. Ng also says that the reason they put this feature into the scheme, the managed wind down, is to give creditors the choice. As I showed Your Honor in the original presentation, the choice of an earlier exit. And as I showed Your Honor in the first presentation to creditors, that's actually not true, because creditors were being told that only some will exit, those who participate in the RDA. Those who don't have to wait for distribution. But if that's now changed and everybody's going to get some distribution at the point of the RDA, whether or not they participate, the question really is, why not just give everybody exactly the same distribution? If your point is...
if I could start with that, Ms. Ng, would what Mr. Chow be describing be accurate?
Oh, Your Honor, so in terms of the initial RDA, it will be an RDA first in the process. Those who do not participate, so let's call it rounds 1, 2, and 3. So for round 1, as an initial, there's 1A, which is the RDA. A portion of the assets that are available will be allocated to the RDA process. And then if it's taken up, it's taken up. If it's not taken up, whatever that's not distributed as part of the RDA will then go to 1B. So there always will be a 1B. It's just a question of how much there will be in 1B. And it will be distributed to all other creditors.
When, sorry?
Short after the RDA closes. So it's part of round 1. Yeah.
After that, the RDA closes, the non-participating persons may get.
Will get. It's just a question of in terms of how much it might be, and that's why there is the analysis of potentially an upside in the RDA. That if you exit at 1A, you might get, let's say, for example, 45%. But then if you do not exit, you then get a small amount in next rounds of Bs for round 1, round 2, round 3 if you stay the course. So it's always RDA first, 1A, then after for everyone else, 1B, and it will be a smaller amount as compared to the RDA in that one. Then when there's a new pool of funds available, so let's say, for example, a major illiquid asset is being realized, the same process is run again. Let's call it round 2. 2A, the threshold for the RDA will be set in terms of the minimum amount of discount. There will therefore be a recovery on that basis. Some part of the monies will be allocated for that. Then for those who do not participate, they will be participating in round 2B of distribution. So they will get money, but it's going to be less than people who get in 2A.
All right, thank you. All right, Mr. Chua, that's their position this morning.
Yes, I hear that now. And my response to that simply is, if everybody's going to be getting a payout at these various points, why not just pay them exactly the same? There's no reason to discriminate if you're going to pay out at exactly the same point. In fact, it's just going to breed more discontent when people see some getting 40%, some getting 27%. Why is there a need to do that? I still don't understand that. And the other thing about this RDA process is actually for it to work in the way it's, in order for it to achieve the economic effect of having, of benefiting those who stay the course, it's actually dependent on a sufficiently high take-up. So your Honor would have seen from Crow's slide that for the first RDA, they put a threshold of 125 million worth of liabilities that they're hoping to extinguish in that first RDA. So they need $125 million worth of debt to participate then. If you look at the poll that my learned friends' clients have run, when they ask the question, who's interested in participating in the fast RDA, they got a response from creditors holding only about 13 million worth of assets of debt. So basically only $13 million worth of debt is interested in participating in this first RDA, less than 10% or about 10%. If that's the case, why are we bothering running this process? If that's a level of interest. And so if you take out the RDAs from the scheme, because in my submission, they are unfair, they don't make sense, they're going to waste money, they're potentially going to delay matters. What then is left of this scheme? What is there to distinguish it from a liquidation? My learned friend had mentioned two minor points, which she couched as advantages. The first is, she said that small creditors could be better provided for in a scheme. In a liquidation, they will likely get nothing. My short response to that, Your Honor, is that in a liquidation, a liquidator has the power to pay any class of creditor in full with court approval, with creditor approval. That's section 1441B of the company of IRDA. And a liquidator can also apply to court for creditor debts to be admitted without the need to file a proof. The court has that power under the court ordered winding up regulation 5. And that's a clear advantage over the scheme process. And that's very likely something that a liquidator coming in will look at, because if you're talking about the nature of the debts here, everybody's got a Vault app on their phone, which should match with the balances in the company's own records. It shouldn't be a difficult process to reconcile these numbers. A proof process may not even be possible, and the court has the power to say it's admitted based on what is reflected in the company systems, in the customer's apps. And to the point that some creditors, the smaller ones, may be too expensive to pay them. You need to go through, it's cheaper to use the existing Vault platform. My short response to that is, that's an option open to the liquidator as well. He could also retain the existing Vault platform, pay whatever maintenance fees is required in order to ensure that distribution is an easier process. Why can't he do that? Then the second miscellaneous point that my learned friend was highlighting as a potential benefit in a scheme that we won't get in liquidation is that, I think she said, and Mr. Darshan has also said, that the liquidator will come in, automatically convert everything to fiat immediately. Again, I think that's a very simplistic way of saying, of looking at how a liquidator would approach this particular engagement. There's nothing to prohibit an in-specie distribution in a liquidation. And if that's the more sensible outcome, that's the outcome that creditors want, and as a platform that allows that to be done, why wouldn't the liquidator do that? Your Honor, I then come to, I have just a couple more points and I won't take much longer. I then come to what is, I say, a major advantage of the liquidation, the court-ordered liquidation process over their managed wind down, which is really a liquidation in disguise. And that's the ability to pursue, to investigate officers for misfeasance, to look at past transactions, to unwind them and challenge them if necessary. A liquidator has access to a whole powerful range of options and remedies under IRDA, wrongful trading, investigations, undervalued transactions, unfair preferences. And none of this would happen in an MWD, the managed wind down. And I'm not just throwing up a couple of scare tactics to say, well, unparticularized areas of concern. We particularize them in Mr. Edelman's affidavit. He's been quite specific as well. And I'll just mention three areas where there are real question marks, which we think really require further investigation. The first is this question of, and you have seen the complaints from many creditors, this question of the situation where the company was accepting deposits before they suspended on the 4th of July 2022, accepting new deposits, but not allowing withdrawals. And so basically they were taking in money, but holding withdrawals of customer funds. One explanation that they tried to give was, look, when it goes, withdrawal requests are made beyond a certain threshold, 100,000, we have to do a manual review, and that's why it took longer. But under their own terms and conditions, a manual review must be completed within 48 hours. And in many, many cases, and we put some examples in Mr. Edelman's affidavit, it was way beyond 48 hours and the funds were still stuck, but they were taking customer deposits. So that's really a point of serious concern. This VOR platform, they well have been insolvent. The management knew that there were financial difficulties well before 4th July, but they still kept taking in money while holding back withdrawal. The second point of concern, Your Honor, relates to at least two of the receivables. The counterparty A loan, the coin loan. Your Honor would have seen from the Kroll slides from Mr. Darshan's affidavits that he is the counterparty to these transactions, not the company, not Defi Payments. And we're now told there are commercial reasons for this, but of course we're not told what these commercial reasons are. It was said at one of the committee of creditors meetings by Kroll that this is common practice in crypto. They see it all the time. Frankly, that's not reassuring at all, Your Honor. There are many practices common in crypto, which we are now finding out are borderline illegal and criminal. That is not a point of assurance. So these transactions, these loans really need to be investigated, and not just investigated generally. There's also this related point which will come up at some juncture. That's this, Your Honor. Let's take the counterparty A loan. We're told there's significant problems, there's significant risks in relation to recovery. It's unclear. What if that loan is fully impaired? For some reason, it's not recovered. Let's say counterparty A goes insolvent, or the contractual documents were weighted against DeFi payments. And we just can't, the entire 106 is written off. In a scheme, that essentially is the end of the matter, because the scheme manager will simply say to creditors, well, look, we told you there were risks, those risks panned out. Sorry, your recovery is 27% for those who didn't take up the first RDA. Not so in a liquidation, because in a liquidation, the liquidator would then say, well, I'm going to see, and I'm going to look more closely at that transaction. Did the directors do their job? Why did they enter into a transaction of this nature? What due diligence did they do? Why did they structure the transaction in this way? And you can pursue claims, enhancing the prospects of recovery. The third point that we think should be investigated and can only be done in a liquidation is this, Your Honor. This has to do with the flip vote receivable. And here, Your Honor, I have to trouble you to turn up a different affidavit. That's Mr. Sanju's affidavit. Mr. Sanju Soruv Korean, his first affidavit. He's only filed one.
Yes, thank you.
Yes, you have that. Thank you, Your Honor. Could I ask Your Honor to go to page 21? Page 21 is a press release from the Indian Directorate of Enforcement in India, where they were explaining to the public about their search on Flipvote and their freezing of certain accounts. Your Honor, can I just go straight to the third paragraph from the bottom? Your Honor will see Yellow Tune. Yellow Tune is FlipVault's customer. Yellow Tune, by using the assistance of FlipVault crypto exchange, which has very lax KYC norms, no EDD mechanism, no check on source of funds of the depositor, no mechanism of raising STRs, etc., assisted the accused fintech companies in avoiding regular banking channels and managed to easily take out all the fraud money in the form of crypto assets. Furthermore, despite giving repeated opportunities, FlipVault crypto exchange failed to give complete trail of crypto transactions made by Yellow Tune, nor could it supply any form of KYC of the opposite party wallets. The lax KYC norms, loose regulatory conduct of allowing transfers to foreign wallets without asking any reason declaration KYC, non-recording of transactions on blockchains to save costs, has ensured that FlipVault is not able to give any account for the missing crypto assets. Made no sincere efforts to trace these crypto assets. Yeah, I pause there, Your Honor. The reason I've highlighted this is because FlipVault is part of the Vault Group. It is part of the Vault Group that runs the exchange business in India. So Mr. Darshan and his management and DeFi Payments cannot disassociate themselves with FlipVault. It's part of their group. And this is what the Indian regulators are saying is going on at FlipVault, which means really it's not correct for the company here to keep coming to court and telling the court, this is about Yellow Tune. The FlipVault receivable has nothing to do with our own practices. The Indian authorities seem to take a very different view. And if these practices were carried over into the company or across the Vault Group, a scheme would whitewash all of that. A liquidator would take a very careful look at that. You know, I'm coming to the last part of my presentation now. I know I've taken enough time. I just now want to deal with creditor, let me call it sentiment as opposed to support. Your Honor has two polls before you, informal polls, one run by the company, one run by the VCA. Maybe I can just cut to the chase, Your Honor. I appreciate that the court doesn't take a vote count at this stage. And if you look at the sample sizes of both polls, they're a fraction of the entire creditor pool. I just like to make a couple of points. The first is, if there's one takeaway from all of these polls, is that there is no consensus between the creditors. There's a group that feels very strongly about liquidation who are very upset. Actually, I think that broad dissatisfaction spreads across the entire creditor group. The second point I'll make is that creditors, these polls actually show that creditors are actually quite confused about their different options. They don't fully understand the RDA mechanism because you have people voting apparently in the Vault poll, people voting apparently in favor of a managed wind down, but against a substantial number of what should be that group against the initial RDA. I have no interest in participating. I would prefer pari passu distribution. And in the Vault poll, you don't even have liquidation stated as an option. Simply asking them to vote against any restructuring proposal doesn't mean that you're telling them you have the option of liquidation. And bear in mind, there's a varying degree of financial sophistication across the board here. So the only takeaway, as I said, is that creditors are tired, they're angry. Probably the one thing that we can all agree on is that they want as much of their money back as possible in the fairest possible way. And that really means we should be going for the simplest, most straightforward solution. And that solution is liquidation. It is not a managed wind down with a series of RDAs that favor one party over the other. Your Honor, if I may, I'd like to just now come very quickly to deal with my application for leave to present a winding up petition. Your Honor is very familiar with the principles. So if I could sum it up, really, it's a balancing exercise. And as far as the benefits are concerned, Your Honor's read my submissions. There are at least two. One is we save time. We put all applications relating to this situation before the court, get it heard at the same time. If Your Honor is inclined to go to allow them to extend the moratorium, and hear them at scheme meeting convening application stage should have this winding up application fixed for hearing at the same time. It's going to save costs. The second is that if we have an earlier start date for the liquidation, that could be potentially significant in terms of the start times for clawback actions, etc., the relation back period. So that's a discernible benefit that we would have if the winding up started earlier. And there's really a risk here that if they go through a scheme process, the applications for the scheme process, that could drag out for quite some time. And we end up then with a winding up that starts maybe several months down the road, which could make a difference. Then what is the countervailing consideration as far as prejudice on their side is concerned? All that they have identified is disruption, confusion amongst creditors. As far as disruption is concerned, this company is insolvent. They're looking to wind down anyway. It's not as if you're looking to rehabilitate. So all we're saying is go for the court-ordered liquidation as opposed to your private liquidation. Why is that disruptive? The second reason given was that it would somehow cause confusion for creditors. Again, explain it clearly. Explain it clearly to creditors what this is all about. There's no reason for there to be such confusion amongst creditors that it's going to affect the way you run your scheme process, etc. Putting it there as an option to creditors and telling them that this could get wound up could even focus their minds if we go down a scheme process and you put it to a vote.
Sorry, Mr. Chua, could I ask you this?
Yes.
Really, what you're saying, the practical effect would be for the court to choose one or the other. If I let your application go through, essentially, I suspect that will mean that the scheme is likely not to, at least there's a strong chance that the scheme may not even come to a vote. So should it be for the court to make that call between these two options, or shouldn't I leave it really to the creditors to vote and make the choice? They can, as Ms. Ng says, the creditors can choose to reject the scheme, and at that point, then some of them may seek to revive the liquidation application if need be.
Yes, Your Honor. So let me just address that point directly. I don't think it's going to have an influence on the vote. If to the extent that creditors see that there's a winding up application on hand, I don't think that that's going to then influence creditors who prefer the scheme approach to say, well, since it's there's a filing on hand, I'm going to go to liquidation. They're still going to assess it on the basis of the information that's been given. What is the better process to follow? Are there really advantages that the scheme process offers over liquidation? And the reality, Your Honor, in terms of case management is if I file this application now, it will get fixed for hearing together with an application for, it will get tagged along with the scheme applications anyway. Well, I'm not going to be able to steal a march and get it wound up before the company even makes that application. So,
Sorry, I don't think I made myself clear. What
yes.
I think, what I wanted to ask is that isn't it really the case if I let your liquidation application proceed, that we're going to be really left with a situation where there'll be binary choices in effect given to all the creditors. So really then there's no point keeping the scheme in place. It's really a choice that has to be made between the scheme vote and liquidation. And given that stark choice, really then I should just really be concerned in my mind about whether I should allow the extension to continue or whether I should allow the liquidation to go forward. There's not much point trying to knock things and not kick the can down the road, basically.
I think Your Honor's put it quite aptly. My primary submission is that the moratorium extension should not be granted. The company. That's my first submission. My leave application is an alternative. If Your Honor feels that an extension should be granted, what I'm trying to do in that particular situation is to have my winding up application put together for hearing. I should have made that.
All right. So yes. So So taking the first scenario, why should I stop the moratoria extension at this time? Have the criteria not been met for moratoria extension, or should I articulate a different principle at this stage? Given, as you said, we have been through a number of extensions. So what test should I apply, and have the applicants failed it?
Yes, Your Honor. The test is the statutory test under 64 of whether the scheme is a feasible one, which merits consideration by creditors. Now, I would submit that that wording is flexible enough for the court to consider. At the point in time when it's heard multiple extension applications, it's some 7-8 months down into the process, to employ a higher level of scrutiny and really to take the approach of looking at the scheme versus what is the alternative. And here, I think that choice is quite neatly laid out because it is clear that the scheme posits a recovery and distribution process. And as I have said, I've tried to persuade Your Honor, that is a liquidation process. And so the court, when it's trying to see if this merits consideration by creditors, and considering a creditor base of 150,000 who may not understand the liquidation process in Singapore at all, the court can take into account, is this scheme, does it offer anything that's superior to a liquidation, which the court well understands and is be able to make that assessment. And
so is that a question that I should answer, or should it still be something that I should lean towards leaving to the creditors to make the choice? Because they can ultimately vote on it. They can say no to the scheme, which would implicitly be a vote in favor of liquidation.
Yes, Your Honor. My submission is that you can make that choice, because that choice is something that is delegated to you under IRDA. You make the court makes the assessment as to feasibility. The court makes the assessment as to whether it merits consideration by creditors. So there is a filter at that stage, and it is no different in substance from the court looking at a scheme and asking itself, does this have a realistic prospect of working? So for example, just to leverage off Your Honor's approach in, say, Aquaverse, I'm not as familiar with the exact facts of the case, but from what I can tell, Your Honor, Your Honor had asked yourself the question, is it really right to put before creditors a scheme, or I appreciate it was in the context of a moratorium extension, a context of a scheme where recoveries are so heavily weighted or based on litigation outcomes, or the success of an app that is uncertain. So Your Honor did ask yourself, in a sense, those sorts of questions as to the substance of the scheme in Aquaverse, in trying to decide, can this really work? In substance, I would say that's not very different from what I'm inviting Your Honor to explore here. Is this scheme really going to be a better outcome for creditors as compared to a liquidation that the court supervises? Bearing in mind, there are no difficult questions here about recovery of assets only being available in a wind down. There's no difficult questions here about a company intending to continue business so that it can generate returns to pay creditors. It's simple. They're going to get assets that already belong to the company, either in the form of liquid assets or through contractual arrangements in the form of illiquid assets. They're going to get it back, and then they're going to figure out how to distribute it to creditors.
All right. And the other question I have is that, going back to the way we split up the two scenarios, if I left it to the second scenario of postponing matters until the application for scheme meeting, wouldn't the fact that liquidation application be pending be distracting? Wouldn't it take up resources or lawyer hours, for example, that could be better spent preparing for the scheme?
Not
There'll
if
be an unnecessary distraction. Yes.
Yes, Your Honor. Not if the direction that the court makes is just for me to file that application, and a case management note is made that that application should be fixed for hearing before directions for affidavits, etc., will be fixed together or in conjunction with the application for leave to convene a meeting. But I also think that if you look at the way the arguments are playing out, the winding up application is going to be straightforward. Company is hopelessly insolvent. There's no dispute about that. And if you don't allow them permission to call a scheme meeting, it should be wind up. There's no other outcome. It's not going to take a lot of lawyer hours to deal with an application of that simplicity. My submission.
All right, thank you, Mr. Chua. Anything
Thank
further?
you.
All right, thank you. Back
Thank
to you,
you.
Mr.
Your Honor, there are a couple of points that my learned friend has made. I'm too conscious about time as well. Perhaps what I intend to do is that to the extent that certain matters have already been set out in that period, I hear Your Honor that you will be taking some time to decide. I'll give you the references.
Yes.
But for certain main points, I think I should highlight at the hearing itself. And one is that in relation to alcohol verse, which my learned friend has made reference to, based on the brief facts that I've seen in the grounds of decision, I think it's quite different from our case. What I understood in that particular case is that a group of companies were pooling their assets together. It was anticipated that with the additional inflow of funds, so what they were talking about, the uncertainty in relation to the damages claim, that was the fresh funds. There was fresh funds which is the equivalent of a cash injection by an investor, for example. And that was contemplated to be used to pay back creditors in full, as I understood from the brief facts of the case. That's very different from what we are looking at here. So that's their scheme. Their scheme is, if there is a damages claim that comes in, the damages reward that comes in, creditors are going to get 100%. So that's a key term of the scheme. Ours is different, Your Honor. Ours is a managed wind down, and I mean, we are not shying away from that. But what the advantages are and the differences between this and a liquidation is that creditors have to say. Creditors have the choice in terms of what they want in terms of timing for distribution, in terms of recovery. Two, they can exercise their own risk appetite in deciding whether to exit earlier or later. And these are creditors which my learned friend says that they don't understand what they want is a fair and pro rata distribution. But I think that's a bit unfair of a statement to make, because the clients or rather the parties who have actually made that submission or are of that view are clearly the 5th to the 9th parties, and a few of the other creditors who have come forward by email or have voiced their responses in the informal poll. But this is not reflective of the general creditor sentiment. In fact, the general creditor sentiment, as reflected in the informal poll that we've done, shows that creditors of a significant number, I would, in my submission, Your Honor, in light of the number of respondents, is that they want that flexibility. They want that option. And what my learned friend is asking Your Honor to do is to make a decision on behalf of the creditors now by saying that, let's go into liquidation. But creditors had that opportunity to say, to voice their vote. And that's the reason why we are asking Your Honor to extend the moratorium and also to give us the chance to put forward the Section 210 application before Your Honor. And to give at that point in time when we make the application, to give the creditors the opportunity to actually make their decision. That's one in relation to Aquaverse. Another thing in relation to the a statement that that creditors want it back via liquidation. I also wish to highlight that it's only 182 creditors based on my learned friend's submission in terms of the informal poll taken by the VCA. 182, but I also wish to caveat, we're not certain that all of them are creditors, but it's 182 versus 1,000 over creditors who are supportive of a restructuring. One of the issues that also my learned friend has raised is that of classification, and he suggested that there might be another category of creditors who have small claims and are being paid in full. I just wish to highlight that I did not, and clarify that I did not say that small claim creditors are going to be paid in full. What I had said in the context of the restructuring plan is that small claim creditors would have an opportunity to be paid nonetheless because of the way the distribution system is going to be set up using the existing platform. It could be $30, $20 equivalent of a token, and they will be able to actually get the token out, as opposed to a fiat currency distribution in the event a liquidator chooses to make that distribution. And there are going to be mandatory administrative costs that are going to be incurred. So for example, a TT transfer of funds that has mandatory bank charges, for example. I do hear my learned friend in that, in a liquidation also, there are opportunities or, avenues for the court and to actually make certain directions. But that's precisely my point, Your Honor, that as a starting point, there are going to be many issues that need to be sorted out. One, in terms of the platform, question mark arises as to whether the existing technical engineers are going to stay on when the company is liquidated. Being an employee of a liquidated company might get some stigma, or the employee might choose to leave immediately. It's out of the control of the hands of the liquidator. That's simply the point I'm making. There is much more uncertainty in that case. And if that happens, a new set of engineers need to come in, recreate the code. That's going to take time and money. Timing wise as well. And I don't intend to belabor that point, but I would just wish to point out two documents, perhaps if I could trouble Your Honor to take a look at. One will be our letter to court, 10th of February, setting out the proposed timeline for this and voting process. And the second document is a response to the VCA's queries that is exhibited already in the 11th affidavit from page 109 onwards. One other thing also, I think I just want to very briefly mention, and this is also set out in the letter, but I think one point that my learned friend had referred to was liquidation costs. And he had made reference to the various liquidations and say that, those are cases where, it's a wrong reference point. Just wanted to point out in relation to MF Global Singapore, and that's also in the affidavit. So that's only MF Global Singapore. It's not MF Global as a whole group. In MF Global Singapore, there was no allegations of any fraud or anything. And that itself had entailed 6,000 creditors. And that process cost an estimated $35 million, as set out in the article. I think we need to be, conservative in terms of the amount of work that needs to be done in dealing with a potential liquidation in my learned friend's perspective. Because of the extent of the number of creditors, the complex issues that are going to arise, it's going to take time and money. And one of the issues are that in relation to the distribution. As I mentioned, the claims itself, it's denominated in 250 plus tokens. How are we going to deal with that in terms of distribution in kind, in specie, as my learned friend mentioned? It's far from easy because the assets don't match the liability. And that's the reason why also, as we have highlighted earlier in my submissions and also in the affidavit, there is an intention to try to minimize that gap and actually rebalance the assets and liabilities to ensure that there is going to be less of a fluctuation in that differential, and also to meet creditors' preference to actually be paid in token. And that's something that has come up quite a bit in the last couple of months. Creditors have said that they want to be paid back in tokens, as opposed to something out of their choice. And this is what we are trying to give to creditors, their choice. One last thing also is that in terms of the allegation that certain creditors might have more inside information, not more inside information, but would have inside information or more information than others. And on this, I just wanted to point out that the COC minutes of meeting have all been exhibited. Whatever that's being told by the company to the COC are told to creditors. They are aware of it. So there is no differential in the level of information that's given. And one last thing in terms of the the RDA and whether creditors understand, it's been explained not just by the company and its financial advisors, but also at the 21st Feb meeting between the COC and the creditors. So there have been a lot of opportunities and forums have been created for discussion, for education, and for feedback to be given. And with that, Your Honor, unless Your Honor has any other questions.
All right. Thank you, Ms. Ang. Right. Thank you both, Ms. Ang and Mr. Chua. As I indicated at the start, I would like to weigh a few things. I had some concerns about the proposed direction of the scheme, but at the same time, I want to weigh how much the court should actually defer or provide an opportunity to the company and its management to try to effect a solution. And I also want to try to see how much the court should respect the autonomy of the various creditors. And it's going to be a, of course, a difficult exercise. And throughout all this, I have to be faithful to the requirements of our law. And I also have to weigh some of the recent emails, some of which have only come up to me this morning. So because of this, I will reserve judgment, and I don't propose to drag things out too long, perhaps about a couple of weeks. So at this point, what I will do, only because I need to reserve my judgment this morning, I will grant an interim extension of 3 weeks or other order of court, which will take us, sorry, to the 20th of March. And what I will aim to do is to give at least brief grounds. Before that, I will arrange a registry to fix a hearing date for me to give my decision before the 20th of March. All right, Ms. Ng, Mr. Chua?
Much obliged.
Grateful, Your Honor. Thank you.
All right, you understand? Anything that you'd like to raise in terms of the timeline, the dates and fixing of hearing? Any blackout dates I should avoid, Mr. Chua?
Yes, Your Honor. Unfortunately, I am traveling in March, but I will inform the registry directly.
All right, thank you. Mr. Chua, similarly, all right?
Yes.
All right, sorry, yes, I realize it clashes with our school vacation. All right. All right.
You know, I appreciate the time sensitivity of the matter. And in the event, you know, that there is no other date that's possible.
No, it's all right. I'm afraid I've got a very tight hearing schedule as well. I'll extend it to the moratorium to the 24th of March, the end of that week. But I'll try to see what date we can give for the decision before the 24th of March. All right, Ms. Ng?
Great for
Mr.
you.
Chua? All right. So registry will confirm a date, and we'll have to ask the applicants to disseminate the date as well after that.
We will do so.
All right. Anything further, Mr. Ng?
Nothing from Your Honor.
All right, Mr. Chua?
Not from me. Thank you.
All right. All right. Thank you both. So the arguments I said today are primarily legal, and therefore I will take time to consider them and issue brief remarks. Right. Thank you all. Court is adjourned, and yes, thank you. Court is adjourned. Thank you.
Court is adjourned.